Welcome to our informational series presented by motenanthelp.org and Missouri Legal Services. In this segment, we will discuss settling an eviction case in Missouri. You can attempt to settle your case during the pendency of your lawsuit. You may wish to settle your case to avoid the time and stress of trial, or if you and your landlord agree on certain things. Settlement allows you and your landlord to agree to terms that best work for you. If you proceed to trial, the outcome of the case will be determined by the judge. Settlements can often be more flexible and better suited to your specific needs. You can initiate settlement discussions at any point during litigation, including before your first court date. However, keep in mind that you do not need to settle your case. If your landlord insists on a settlement agreement that does not work for you, it is your right to present your case to the judge for a decision. Usually, settlement discussions begin on your first court date. After the docket is called, judges encourage tenants and landlords or their lawyers to explore settlement. Remember, the opposing lawyer you speak with on your first court date represents your landlord, not you. This is important because your interests directly conflict with your landlord's. If you would feel more comfortable, you can also have a friend or family member attend court or review any potential settlement with you. You do not need to reveal anything to your landlord or their attorney at that time. You do not need to settle your case on your first court date. Judges will usually allow a tenant 1 continuance. If you need time to review or consider the agreement, then take that time. Any settlement you agree to should be in writing and signed by both parties. One common type of settlement in an eviction case is called a consent judgment. A consent judgment is different than a usual settlement agreement because it is an enforceable court judgment. Whatever you agree to in the consent judgment, whether it is how much rent you owe or the day on which you must move out, is enforceable as a court judgment. Tenants should be careful when deciding whether to sign a consent judgment. The terms often favor landlords, sometimes granting them the right to evict you and collect on all of the back rent and fees they claim are owed faster than a trial judgment. This can be a bad deal for the tenant, especially if you disagree with the landlord's claims. Once you sign a consent judgment, it is very difficult to set it aside, and you are likely to be bound by its terms. Keep in mind that a consent judgment is still an eviction judgment on your rental record. Sometimes, parties will agree to a consent judgment with a stay. Stay is a legal term for pausing or stopping a legal proceeding. Judgments are entered by the court and then executed, meaning enforced. The stay applies to the execution of the judgment. This means that although the judgment has been entered into the court record, it will not be enforced if certain terms are met. In the eviction context, this usually looks like a consent judgment giving the landlord possession of the rental and back rent owed, but with a stay preventing execution of that judgment if the tenant moves out or pays a certain amount by a specified date. Be sure to read the consent judgment carefully. Any repayment plan you enter for back rent does not change the fact that you still owe your normal rent as it becomes due. The terms of the stay often require that you timely make both your repayment schedule payments and your normal rent payments. The terms of the stay are strict. If you do not satisfy a term or are late, your landlord can seek to execute the judgment and evict you. Another common settlement arrangement is called a pocket consent judgment. With a pocket consent judgment, there are usually 2 written documents, a settlement agreement and a consent judgment. This option is attractive for tenants because it can prevent entry of an eviction judgment on your rental record. In the written settlement agreement, the parties will agree to terms. Usually, this means the tenant agrees to move out or repay a certain amount by a specified date. If the tenant meets those terms, then the landlord agrees to dismiss the case. If the tenant fails, then the tenant agrees that the landlord can enter a consent judgment for what the landlord is seeking. In this arrangement, the consent judgment is not actually filed or entered when the agreement is made. Instead, it is held onto by the landlord, or kept in their pocket, in case the tenant does not meet the agreed-upon terms. If you cannot reach an agreement to settle your case, you may still be able to resolve your case without going to trial by utilizing Missouri's pay and stay law. This law allows a tenant to stay their eviction case if they pay all rent owed, and the landlord's court costs before a judgment is entered. Rent does not include things like late fees, utility fees, insurance fees, or attorney fees. Look closely at the petition and other filings to determine how much is owed specifically for rent. You can make the payment in court on any court date or trial date and indicate to the judge that you are using your right to pay and stay. Be sure to get a written record of payment. Your landlord or their attorney will often push for a consent judgment for possession and/or all of the rent, fees, and attorney's fees they claim are due. But if you know the facts of your case and the settlement options available to you, you may be able to negotiate a better deal. Always remember, you do not need to agree to the terms presented to you. You can respond with your own terms or demand that a judge decide your case. Eviction court is an intimidating experience, and landlord lawyers have an interest in settling your case quickly. Do not let their pressure tactics affect your decision-making. Take your time to review the agreement. If you are still unsure on your first court date and need more time to decide, you can request a continuance from the judge. If you believe you may need to defend yourself in an eviction proceeding, you can find other helpful resources online at motenanthelp.org. By being informed, you can better navigate these legal processes and protect your rights. For more detailed information or legal advice, consider consulting an attorney. The information in this video is not legal advice.